All right. What is up, co-counsels? I don't know why I put this up here. Let me delete this. Okay. All right. Let me share my screen. We want to go back to, I believe it's Dr. Wolfe. I was trying to find the video on the back end here, but I did not want to keep anybody else waiting. So let's see where. I was trying to find the exact.
Some of my courses included physics, statics, dynamics, thermodynamics, fluid mechanics, your engineering sciences. Subsequent to that, I then went on to pursue my PhD in electrical and computer engineering with a concentration in, this is in slow motion, correct, not real time.
Okay.
We're able to pull our surveillance.
Let's see if we can get across.
Delete them. It just, when you swipe, it just deletes the text chain.
After you deleted them, did you go into leave?
That sounds like Brennan. So let's find the beginning of that cross-examination. He actually was not on direct for as long as
Next slide, please.
anticipated. Okay, I think that's
And what are we seeing in these series of photos?
So this is...
all right, let us get in here.
Put us back in session. You may be seated.
So jurors, we are going to stop today at 3:45. All right, Mr. Brennan.
Thank you, Your Honor.
There's not a housekeeping before Mr. Brennan gets started.
Group.
The addition of subject redactions. Mr. Brennan and I put on.
All right, so, okay, great. Thank you.
Oh my, so in the Diddy trial, the jurors were shown the freak out videos. I don't know what to make of that.
Biggest question remains.
I don't know. That's some disturbing stuff out there.
All right, do we have the actual? Okay, great. Yep. So,
Exhibit 216.
thank you. All right, Mr. Brennan.
Good afternoon, Dr. Wolfe.
Good afternoon.
When you testified in direct, you shared with the jury some of the work that ARCA does. Do you remember that?
Yes.
And you had mentioned a couple interesting things, that there had been some work.
Oh wow, the American Bar Association is suing Pumpkinhead. Let me see, what are they suing him for? Blah blah. Okay, so basically to stop his efforts to punish law firms.
With the Department of Defense.
Correct. Yes.
The work with the Department of Defense, was that during your time or before you got there?
That would have been prior to my employment. Yes.
So when you were telling them about working with the Department of Defense, that really had nothing to do with you. That was ARCA before you began working there.
ARCA as a whole, yes. The work that we do, yes.
Not you.
As I said, I wasn't involved specifically in that project, no.
And you mentioned that you did some stuff, or the company does some things for the NHL.
Yes.
You didn't tell us much more about what you do. There's other things that ARCA does as far as clients, right?
Certainly.
Did you share with us that you work for lawyers and law firms?
Yes, we do.
And you do litigation?
Okay, I'm trying to understand this line of questioning. Let's see where Brennan is going with this one.
Insurance companies?
Yes.
Okay. Is there any reason why you highlighted the Department of Defense that you don't do and the NHL, but didn't share the rest of the stuff with us?
That's just some of the prominent clients that we have.
I see. You provided us a CV, didn't you?
Yes.
And that's like a resume.
He's trying to paint a picture. Let me see. Why is Brennan asking this line of questioning?
Resume tells us a little bit about your education experience. You get to highlight some of the things, your accomplishments.
Yes.
You shared with us you've been the director of accident reconstruction at this company, ARCA, since 2017.
Air conditioner
No, not since I started.
You started with ARCA in 2017.
Correct, yes.
When did you become the director of accident reconstruction?
I think that would have been in January of 2024. So about a year and a half.
About a year and a half ago?
Yes.
And you received your certification from ACTAR.
Yes.
Did you pass the test on both parts first time?
I don't recall if it,
Did he fail a little bit? What's going on? What's going on?
I think it was I had to retake, I think the practical section in the afternoon.
Well, you,
I think it was I had to
Okay. Brennan,
retake, I think the practical section in the afternoon.
retake. Did you fail? And then many talk.
well, you would recall something like that, wouldn't you? Did you pass both parts on the first try?
Like I said, I think it was the second part I had to retake.
Well, this is a pretty important test, isn't it?
Not really.
It's your certification.
Apparently not really, so he could fail it.
It is, but much of the concepts that are covered in it are very elementary.
Well, not so.
Well, I would not say that if you have to retake or if you had to retake it.
Elementary. You had a hard time with part of it, didn't you?
Well, with respect to the portion that I had to retake, it's a practical exam where you have to reconstruct an accident. You have to determine approach angles, departure angles, and it can be very sensitive to those inputs. And unfortunately, if you mess up one of your first angles and you carry out that calculation, then the whole problem is graded wrong, even if you did all of the math correct.
Okay, so he's basically trying to paint this guy as some incompetent individual. What's up, Brooklyn? I got your email today. What's up, Benji? How are you guys doing? He wants payback for Dr. Welcher. I would have thought that he probably wanted payback for Mr. Burgess. That's what I was thinking. But again, I'm watching this stuff for the first time. And so I don't exactly know who the payback is for.
So we understand.
Hope you guys had a good Monday. I just decided to come up here so we could catch up. I'm sorry about Saturday, but I was exhausted. Could not. I worked on Saturday, so I could not come up here again because I was done.
And there's a multiple choice question part. That's the easier part, correct?
I don't know. It's easier, but there is a multiple part. Multiple.
I did upload a Can Read Shorts today. I'm out of control, you guys. So, I mean that I had to redo it because the first take I was just way out of control. This one is still kind of out of control, but it's tasteful.
Choice part.
There's a more practical part where you actually have to go out in the field and do assessments, kind of like the things that you did today.
You don't go out into the field, no.
And, when did you first take that second part that you did test?
I don't recall.
You don't remember when you took the test?
No, I don't.
Suffice to say, you took it again.
Correct.
And ultimately, you passed both sections of that test?
Brennan is nice. Instead of my line of questioning, instead of saying, suffice to say you took it again, I will pretty much have him admit to actually failing the first time, literally using the word failing. That's probably a favorite word of mine. Every time I write, or most times I write a motion where I'm arguing against the opposing party. When it comes to burden of proof, I always say that the opposing side failed to prove their burden of proof. It's a word I enjoy.
Yes.
I think it's more impactful.
In your CV, you list your schooling and you list your degrees, don't you?
Yes.
You mentioned some of the things that you focused on in your academic experience, don't you?
Yes.
And you have publications.
Correct.
Recently, you did a publication regarding vehicle control history on Toyotas.
Correct.
Vehicle control history is data that is stored in a vehicle,
Yes.
and Toyota owns Lexus, correct?
Correct.
So you have familiarity with vehicle control history. In fact, you have a publication on it.
Yes.
In your entire resume, you only mention pedestrian collisions or that you're involved in pedestrian type events 3 times. Is there anything specific in your resume or your publications that show a published accomplishment, for example, in pedestrian collisions? Do you have any publications that have been peer reviewed or published in that area?
No, I don't have any publications in pedestrians.
You write or you note areas of specialty and you list a bunch: accident reconstruction, human factors, EDR, commercial vehicle, HD EDR, pedestrian bicycle accidents, nighttime visibility, and a number of others, correct?
Correct.
Is there anywhere in your resume that notes particular classes that you've attended and completed regarding pedestrian collisions?
No, I haven't taken any classes in that.
You haven't taken any classes on pedestrian collisions?
No.
Have you ever taught regarding pedestrian collisions?
No.
Have you ever been a speaker in a presentation about pedestrian collisions?
Yes.
Okay. Is that listed in your resume?
I don't list lectures or presentations, no.
He's trying to say his resume is not complete.
You were asked questions about your involvement in this case. Yes?
Yes.
And you had shared with us that you, at the beginning, were working for a separate party or a third party, you said?
Yes, another agency.
Another agency.
And at some point, you came into court and testified last year.
Yes.
What is this?
And during the time before you came in to testify, you weren't wholly independent of the defense, were you?
With what?
Well, certainly before all of our testing, at the point at which we did all of our testing, report, and analysis, as I mentioned on direct, I didn't know the Commonwealth or the defense in this case.
My question, more precisely, before you testified, before you came into court and gave your testimony, you weren't totally independent from the defense, were you?
No, I mean, I had to communicate with them to be able to determine when to appear for testimony.
So you were communicating with them, yes?
Yes.
And in fact, some of the time that you
Okay,
spent-
so I suppose we're getting into the text messages sooner as opposed to later, because Brandon wants to discredit him from the onset. Okay, so Brooklyn meant Burgess, and Benji saying hi to Brooklyn. Got it.
ARCA actually built the defense for, and they paid that bill, didn't they?
Eventually, after the trial, yes.
During that time, you know what a sequestration order is, don't you?
Yes.
Do you think that you're under a sequestration order today?
Yes.
Did you talk to anybody about any of the prior testimony in this case before today?
No.
How'd you get here today?
How did I get here today? I took a car ride over from the hotel.
Who drove you?
It was a driver. I don't know his name.
Who set up the car?
Well, I suppose they learned their lesson from Dr. Russell. So they're not sharing limos anymore.
It would have been someone on the defense team.
Was it like a window, like a limo?
It was an SUV.
Oh,
Was
so
there anybody
sorry, no limo for him. SUV.
from the defense with you on the ride over?
There were 3 young ladies in the back seat. I think they might have been interns, and Mr. Woke.
And who?
Mr. Wolke, I think is it pronounced?
His name?
Am I saying it wrong?
Have you discussed anything about this case before your testimony today as far as the trial?
Before today?
Yes.
Yes.
Have you discussed anybody's testimony in this case?
Nobody's testimony, no.
That was different last year, though, because before you testified last year, you did have discussions about testimony, didn't you?
Not with the Commonwealth or the defense, no.
But I'm asking, though, you did have discussions about testimony before you testified last year, right?
Correct, yes.
And you know what a sequestration order is, don't you?
Yes.
After you testified last year, the court ordered you to provide all of your text messages, all your communications with the defense, didn't they?
Yes, earlier this year.
And when you were ordered to provide all of the actual verbatim communications with the defense, did you provide those communications?
Yes, all of the records that I had at the time I provided.
Well, not the records. You know what I'm getting at. Did you provide the communications?
I provided everything I had in my possession, sir.
A text message isn't just a time and date. It's actually substance when you text somebody, isn't there?
Correct.
And when you texted, how many texts?
Oh, this is what I realized. During the voir dire of Wolfe, Brennan was much more aggressive than he's being right now.
With the defense.
From what I recall, I think it was around 50 texts that I sent.
It wasn't 100, I think it was 50.
Well, I think it was around 100 total in terms of back and forth, but it was, I think, 50 that I sent.
And during those texts, communications, conversations, correct?
About logistics, yes.
Did you provide the content of those text messages when you were ordered to by the court?
Well, those text messages spanned from, I guess it would have been April or so of 2024 through May to June of 2024. Ultimately, I think I received the court's order in May of this year, April of this year. So it was a year after the fact, and I had already deleted the text at that point.
How many of those text messages did you delete?
I just swiped the conversation, so it would have been the whole conversation.
Not how you did it. How many of those 100 or so text messages did you delete, sir?
It would have been the whole text chain. I didn't individually delete them. It just, when you swipe, it just deletes the text chain.
After you deleted them, did you go into the recently deleted and then delete them so they were unavailable?
I don't recall doing that.
Well, you were asked to search your records for the text messages. Did you do a thorough search to see if you still had them or whether you had destroyed them all?
I checked my phone, and I also checked with my phone carrier.
So do you know if they were still under the recently deleted part of your phone, or did you go and take that extra step and totally destroy them?
From what I recall, I did not find any of the text messages, no.
Is there any reason why you deleted all of your text communications with the defense?
Well, it's something that I routinely do. I work with attorneys and clients all the time, whether it's appearing for trial or inspections, and I don't have a habit of keeping a text chain that talks about logistics and things. It's just I routinely delete them after that communication is over with, and certainly after the prior proceeding, once it had concluded, there was no reason for me to preserve those.
And so at some point you switched from text messages to another form of communication, didn't you?
Yes, earlier this year.
Tell us a little bit about this new form of communication, not text messages.
Mr. Jackson had indicated that he and his defense team utilized an application known as Signal for their communications amongst their defense team. Ultimately asked if I would also use that application to communicate, which I agreed to.
Is Signal an encrypted app?
It's a secure encrypted app, yes.
It doesn't leave any records, right?
I don't believe so, no.
Well, you have it. You're using it. Do you have any records from your Signal use?
I'm going to allow that.
Do you have any records from your Signal use?
I do not, no.
So you know full well that Signal as an encrypted app leaves no record.
There may be a setting that you can change. I just know that the way that it was set up, there was no record.
Who set yours up to have no record?
I don't know. I think it was default.
Have you ever checked your Signal app to see if you have any record of your communications pursuant to that court order?
Well, I don't have the application anymore, but at the time I did check the application.
Out of all these clients that you've had, how many times or how many clients would you use Signal with?
This was the first time.
Have you used it since with other clients?
Not yet, no.
Before you testified last time, at the last proceeding, or should I say when you testified at the last proceeding, kind of like today, you attempted to portray yourself as totally independent, didn't you?
Sustain enough.
When you testified at the prior proceeding, did you attempt to portray yourself as totally independent?
Yes.
The truth is, before you testified, you were communicating with the defense and attempting the best you could to assist their cause, weren't you?
I wouldn't characterize it that way.
So before you testified, you wrote out questions that you thought could help, that you should be asked when you testified, correct?
So something I routinely do before testifying is prepare an outline of topics and questions that would best help be able to get out my opinions and the analysis I undertook, ultimately so that you all have an understanding of what I did.
So I'm asking you a question. You gave the explanation, but you're skipping over the answer to my question. So
Sustain.
I'll ask you again. Before you testified, did you write out a list of questions that you wanted to be asked?
Yes.
And when you listed out the questions, you also listed out the answers, didn't you?
A general response. It wouldn't be verbatim to that.
I didn't say verbatim, but did you list out the answers to each and every one of the questions that you had prepared?
Yes.
So for every question is an answer that you provided so that you could follow a script, so to speak, yes?
I wouldn't characterize it as a script.
One of the questions asks, so not being able to inspect vehicles is something that is not uncommon in your line of work? And your answer, absolutely not. Remember writing that out?
Yes.
And you put a footnote, a comment. And you said, not sure if you want to put this somewhere in the direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. If you need to show the jury, it doesn't matter in this case. Did you write that?
Yes.
When you're talking about they, I have a feeling they are going to argue I didn't personally inspect the vehicle. Who's they?
That'd be the Commonwealth.
And so when you were writing out these questions as is your routine with the answers,
Maybe it's because this is the second time that I'm hearing this line of questioning again. It does not sound, but then again, I'm also not quite here and I'm exhausted. So maybe that's why it's not as impactful. I don't know.
is this the mark of independence to you?
Well, I think, again, whether the Commonwealth asked me that question or the defense asked me that question, my response would be the same. It wouldn't change depending on who called me to testify. There are a number of cases, by the time I get involved, the evidence is gone from the roadway, the vehicle is gone. So it's certainly not necessary to inspect a vehicle. And I wanted the jury to have an understanding that because I didn't physically inspect the vehicle, it didn't affect my analysis in the case.
So you think that showed independence?
Yes.
Then you also had another question. Would it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? Remember that?
Yes.
You said, yes, unfortunately, there is a direct correlation between time of day and pedestrian fatalities. Is that true?
Correct. Yes.
And they happen more often in the day or at night?
More often at night. Yes.
Yeah, I was about to say this. So pretty much the questions that Wolfe did not, or at least that he wanted the defense to prepare for, he has pretty much highlighted those questions and the jurors get to hear the responses. What I mean by that is he did not, or he wanted to caution defense about the prevalence of crashes occurring at night and potentially, what is that, burying that fact. But because of the notes or the trail that he left, the jury now gets to hear that.
Statistically speaking, by the way, this case involves nighttime, doesn't it?
Correct.
Statistically speaking, most of pedestrian fatalities occur during the evening and night hours. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Did you write that?
Yes.
In fact, you testified, you shared that with the jury, didn't you?
Correct. I've testified to that twice last year as well as this year.
And in the notes that you wrote, When you shared it last year and this year, was it an important point to the jury?
I think so, because it helped gave them an understanding, I think, of my background and lighting and human factors. And as I mentioned earlier today, there's a direct correlation between time of day and pedestrian impacts, right? So my specialty in lighting and human factors results in me seeing many, many different types of pedestrian impacts.
So if it's important, why did you include a note? If you don't want me to say this, that's fine. Why did you include a note to the defense that if they didn't want you to say something that you thought was important, you would leave it out?
Well, I think because I didn't want to confuse the jury about a statistic that just because we have inclement weather and dark lighting conditions, it doesn't automatically equal a pedestrian impact, right? We have to look at the evidence and the damage to the vehicle and the injuries to determine whether or not a collision occurred, not the visibility.
So you weren't trying to mislead the jury, you were trying to help them because they wouldn't understand something that you were trying to explain? Is that the way you're phrasing this?
I think at the end of the day, it was to help them understand my background, how it relates to seeing a lot of pedestrian impacts.
Something was important, and it helps the jury get to the truth. Why would you offer to leave it out?
Well, I didn't leave it out.
No, but you offered to. You would have if requested. Why did you invite, why did you invite somebody else to interject in your independence and guide you to leave something out? Why would you even provide that invitation to them?
Again, it's because I didn't want them to get hung up on a statistic that just because we have more pedestrian impacts at night and in bad weather, that this alleged incident happened at night under bad weather, to give it more weight, to weight the evidence more because of that statistic.
You done?
Yes.
What's going on? Brandon.
If you make a mistake in court under oath, would you take the affirmative step on your own and correct that mistake?
I'll allow it.
I would do my best to do that, yes.
Well, when you say do your best, would you do that if you became aware of it?
I'm going to allow it.
Yes.
Before you testified in the proceeding last year, there was a hearing that you testified in front of Her Honor and other people that were here, correct?
Correct.
I wasn't here.
No.
You were.
Yes.
And you testified about your experience, didn't you?
Correct.
When you were
Yes.
sharing your experience with the court, it was important for the court to have an accurate understanding of what your experience was because it was being evaluated in that hearing, wasn't it?
Correct.
When you testified to the court, you testified that you had been qualified as an expert to testify over 20 times, didn't you?
I don't have the transcript. I believe I said approximately 20 times.
The reality is you hadn't. You've only testified and been qualified 11 times at that point.
Correct. I misunderstood the question. I thought it also encompassed deposition, so I added those two and approximated at 20.
And at some point when you realized you had made a mistake in your testimony to the court, you had a chance to come back when you testified last year and fix it and clarify the record, didn't you?
Correct, which is why I provided a comment with the specific breakdown for clarification.
And when you came back and testified under oath the second time, on the record, under oath, did you clarify and fix the mistaken testimony that you had provided these days earlier?
I don't recall being asked the question. No.
It wasn't whether you're being asked. The question is, did you take the affirmative step to fix the misstatements under oath that you made?
Objection.
I'm going to allow it.
Yeah, that's sure. I know what you're approaching for. That is a proper question. All right, let's fast forward. Let us fast forward. And I really like Alessi. He's such a gentle, waiting for everybody else.
After your first testimony, you appreciated that
Yeah, I don't know why they were approaching, maybe to give the witness some breathing room, but this line of questioning is proper.
you made a statement under oath that was wrong, didn't you?
Yes.
In fact, you made a note. I realized in my testimony I said about 20 times.
I watched a really old movie. I wanted to say this weekend. It was really on Sunday. I watched a really old movie. It's called 187. Literally, the numbers 187. It stars Samuel L. Jackson stars in the movie, and it was a wild movie. The movie centered around inner city schools. He worked for a school in New York City. He got stabbed on the job, so he moved to California. He was a substitute teacher, worked for another school. It was wild out there. The teachers appeared to be terrified of the kids, and the plot twist was really crazy. So this man started offing the students. He started offing the students, the troublesome students. I did not see that coming. It was very disturbing. Apparently, it was written by a teacher, and I don't know what to make of that. The fact that it's written by a teacher, I'm like, okay, are you fantasizing? Are you just bringing attention to this? What's going on? Anyways, I watched the movie. Brooklyn says he was pushing to hear the words FBI. Why do you think that?
When you asked me how many times I've been qualified, I misinterpreted your question, which was my fault, but I'm looking at my D&T list.
Use the microphone.
11 trials, 7 depositions, 18 testimonies total. Not sure if you want to clear it up or just leave it.
Correct. Yes, sir.
Did you just leave it?
I'm not responsible for asking the question, sir.
Do you ever heard the terms confirmation bias?
Yes.
Do you know what confirmation?
I suppose he's using the defense, a line of questioning against the defense witnesses.
Bias is generally?
Generally, yes.
Do you think that you suffer from any confirmation bias in this case?
No.
Do you have any close family that supports one side over the other? Not the facts of the data, but one side over the other.
Close family?
Yes.
Not that I'm aware of, no.
Wife?
Wait, what's the question?
Aware of, no.
This case. Do you ever heard the terms confirmation bias?
Yes.
Do you know what confirmation bias is generally?
Generally, yes.
Do you think that you suffer from any confirmation bias in this case?
No.
Do you have any close family that supports one side over the other? Not the facts of the data, but one side over the other.
Close family?
Yes.
Not that I'm aware of, no.
Wife?
My wife?
Yes.
I don't really know what her thoughts are on the case.
May I approach?
Yes.
All right, Brooklyn. Brooklyn says wife is a free carrying reporter on Facebook. I don't know. Did the defense not look into that? They probably did not. Yeah, because
I don't really know what her thoughts are.
Wife? The data, but one side over the other.
Close family?
Yes.
Not that I'm aware of, no.
Wife?
My wife?
Yes.
I don't really know
Smirk.
what her thoughts are on the case.
May I approach?
Yes.
Take a look at that document. Have you seen that before?
No, I have not.
Never seen that.
No.
Take it back.
You're unaware of anything that may influence you to lean one way or another?
Correct.
When you first took a look at some of the facts in this case, you had some information. Since then, you've received a lot more, haven't you?
Correct, yes.
part of your testimony today to this jury was to provide opinions that you do not think that the holes in Mr. O'Keefe's clothes are consistent with some type of collision. Is that fair to say?
Yes.
In coming to that opinion, you relied on some of your testing that we saw in those videos, didn't you?
Yes.
And that testing involves a hybrid 3-arm, doesn't it?
Correct. Yes.
A hybrid 3-arm is an arm from a crash dummy.
Yes.
That's not the technical name, but that's what it's often referred to.
Yes.
And you and Dr. Rentschler have been working together on this case, haven't you?
Yes.
You've discussed ideas and shared thoughts.
Yes.
In fact, you've worked so intimately together, you know some of the things he's going to testify if he comes to testify, you've said many times today, right?
Yes.
And so some of the data that you shared and some of the opinions overlap with each other, wouldn't you say?
Certainly, he's going to rely on a lot of that test data. Yes.
When you were forming your opinion about holes in clothes and potential abrasions to somebody's skin, all of those tests, all of those that you did, were using a crash test dummy arm, weren't they?
Yes.
In your report, you cite, or Dr. Rentschler cites, 3 different sources regarding testing clothing and skin, correct?
I'm not sure.
Well, haven't you read his report?
I've skimmed it, but I don't know what the basis are for his opinions.
Did you see footnotes 24, 25, 26, 24 being skin tissue cutability and its relation to lacerations, severity, indices? Did you read that?
Let's see if there's a foundation.
No, I didn't read that reference.
Did you read 25, the book that is cited, Forensic Pathology, 2nd edition?
I'm going to have you come to sidebar.
The judge is freaking out a little bit. See how far we can get. What time is it? Okay, that's a long sidebar.
Let me again ask you about this book that is cited in Dr. Rentschler's report. By the way, have you read Dr.
Sounds like the objection has been overruled.
Rentschler's report?
As I mentioned, I skimmed through it.
So in all of your preparation with Dr. Rentschler, you merely skimmed through his report? You didn't take time to read and study it?
Well, none of my opinions are based on work that he did. He's undertaking a completely separate aspect in the analysis.
But that's not the question. The question I asked you was, did you, in working closely with him, take the time to study his report?
As I mentioned, I skimmed it. I didn't read through, as you mentioned, all the references or what he cited. I didn't do that.
Did you read his report?
I did read the report, yes, but I didn't in depth go through each reference and look at what he was citing.
So you read his report?
Yes.
And when you read his report, did you see there were footnotes for a number of different propositions that he made?
I know that there were footnotes in the report, yes.
Well, on the issue of whether or not crash test dummies should be used during experiments as a basis for an opinion of whether abrasions can happen through cloth or an arm, wouldn't that particularly interest you since you were going to come here and testify about it multiple times in front of this jury?
I'm not sure I understand your question.
You knew you were going to come in here and suggest to the jury that you thought that these tests were inconsistent with causing any type of holes in clothing similar to Mr. O'Keefe's or abrasions on his arm. You knew that was going to be part of your opinion today, yes?
Yes,
As part of forming a valid opinion that people can rely upon, wouldn't you want to do as much study as possible on the background for that opinion before you give it to a jury?
I suppose, yes.
Well, you suppose. Don't you think if you come in here as an expert, the jury is relying on your background and education?
Yes.
And they're relying on the fact that you're representing something definitively or with an opinion to a reasonable degree of certainty? You understand that, right?
Yes.
And don't you think when you do that, that it's important that you have proper study and foundation before you just come into court and give an opinion?
Well, I will note that the ATD crash dummy is a generally accepted test device to use for not only assessing occupant forces in motor vehicle crashes, but also to assess impact forces. So that the use of that device is certainly generally accepted.
When you get uncomfortable with my question, you generally tend to answer a different question.
Sustain, Mr. Brennan, next question. Strike that, Jules.
Let me ask you again. Don't you think, as an expert, it's important when you come in,
Well, apparently Brandon is not as composed,
and you're going to present
or at least he's argumentative.
an opinion based on science or engineering or whatever you want to do, that you study the basis for that opinion before you give it?
Yes.
When you saw in Dr. Renzel's report references to this very issue about what should be used when you're doing demonstration or study of what can cause tears to clothing, weren't you interested in the basis for those opinions?
Well, again, it was something where Dr. Rentschler and I worked together, and we were in agreement that we could utilize the ATD arm clothed.
When you decided to have an agreement that you could use that arm, did you read
The book that he cites as support, Forensic Pathology, 2nd edition, Vincent J. DeMaio? Did you read it?
No, I did not.
Did you brief it?
No.
Did you peruse through it at all?
No.
When you decided to come to this agreement that's going to have a foundation for your opinions, did you look at footnote 26, understanding the acute skin injury mechanism caused by player surface contact during soccer, a survey and systematic review? Review that.
No, sir.
Have you seen any articles that support the proposition that a hybrid 3 arm of a crash test dummy is appropriate to use when you're trying to provide a foundation for an opinion about whether or not tears can happen to clothing or abrasions to skin? Do you have any support for that in your report?
Well, again, Dr. Rentschler is going to be addressing the. You're shaking your head.
So I'm going to let him answer the question, please, Mr.
So as I mentioned, Dr. Rentschler is assessing the injuries to the arm. Okay. He indicated to me that we could utilize the hybrid arm to assess the injuries to the arm.
So you have no independent experience or research or knowledge, not Dr. Rentschler, you don't have any independent research or science or knowledge to support your idea, your theory, your opinion to this jury about the tears to the clothes and to the skin.
I was relaying the observations from the testing that we conducted with the ATD. Ultimately, like I said, Dr. Rentschler, it's my understanding that he will testify to the abrasions or the lacerations to the arm.
You've given multiple opinions about this to this jury, haven't you?
Correct, yes.
I'll ask you one more time. I'll ask it this way. Name, other than someone called Dr. Rentschler, name the papers, the studies, the learned treatise, name the resource material you relied on as the basis for those opinions. That a hybrid 3 arm can be used in these type of demonstrations as a basis for that type of opinion.
I certainly, ATD crash test dummies can be used for impact testing, yes.
Not impact testing. You're talking about tears to clothes, abrasions to skin, and I'm asking for the third time. Name one journal, one paper, one study that supports your proposition that you're relying on for the basis of your opinion in front of this jury today. Name one.
I did not cite any in my report, no.
Can you think of one that you didn't cite?
Not that I'm aware of, no.
You had mentioned on direct examination that when you first started looking at materials some time ago, at the beginning, you were unconstrained in the scope of your study. Is that fair to say?
Are we talking about 2023?
Yes, we are.
Okay, yes.
You were unconstrained. You could have done anything you wanted to.
I don't know about anything.
When you said unconstrained, what did that mean?
Well, the agency that retained us didn't ask us to do specific work per se or specific tests.
You didn't do any type of crash test at that time, did you?
Not like was demonstrated today, no.
Instead, you started a working theory that perhaps a glass was thrown at the rear taillight of the defendant's car?
Yes.
Did someone suggest to you that was a theory?
No.
It's just something that you and Dr. Rentschler thought up together?
Based on the evidence that we had, yes.
When you thought up that as a potential theory, that's why you built the potato cannon?
The pressurized cannon, yes.
Pressurized cannon. And you shot a glass at the rear taillight, yes?
Yes.
You determined that at 37 miles per hour there'd be similar damage?
Yes.
And then you came into court last year, didn't you?
Yes.
And you provided that opinion of consistency to the jury, didn't you?
Yes.
You got up and you said that something to the effect that that speed is consistent with the damage?
Yes.
Now, when you gave that theory last year to the jury, did you know about other evidence in this case? For example, if a glass was thrown at the back of the car, how would the bottom of the glass bounce off the car and land near Mr. O'Keefe's body?
What's up, Allie girl? What's up? What's up? Yeah, I know it's not my usual schedule, but we need to get up here and get this over and done with while we wait for this verdict.
Ask it differently.
Did you consider when you came in last year and opined, gave your theory about a glass being thrown at the tail light was consistent with damage? Did you think about how if a glass was thrown at the rear tail light, the bottom would have bounced off the vehicle wherever it was and landed in the air? So he fly?
I'm aware that it was found near his body, yes.
Knowing that it was found near his body, well, you knew his body was about 7 or 8 feet off the road, didn't you?
Yes.
Knowing the bottom of the glass, the broken glass was found near his body 7 to 8 feet off the road, did you consider if somebody threw a glass and broke that taillight, cross your mind how would the bottom of the glass bounce with him to where his body ended up?
No, I did not analyze that part of it.
If a glass was thrown and bounced off that car, did you consider how its speaker would be left in the car?
No, I did not evaluate that.
If glass was thrown at the car and broke the taillight, did you consider how the debris field would end up on the line?
Well, it's my understanding, I think that there were plows that came through that night. So I don't know that where the debris field was eventually found, if that's where it would have been at some point earlier.
Did you ever talk to Lieutenant O'Hara or anybody from the state police to see if the plows went all the way to the side of the yard or just down the middle? Look into that at all?
No, I did not.
Did you give any careful consideration to if the glass was thrown and hit the back of that taillight, how would it be a debris field on the front lawn of somebody's yard?
I don't think that was a part of our scope. It was more or less to determine whether or not if the taillight was impacted by a projectile like a glass, could you get generally consistent damage to that taillight? That was the objective of the test.
So when you came in and testified last time, you weren't considering all of the other evidence that may not support that theory, were you?
I think our objective was to determine whether or not the damage was consistent with an interaction with Mr. John O'Keefe, and could there be another mechanism to cause the tail light to break?
Is there a reason why you were backing off that opinion on direct examination today?
Objection.
You weren't fully embracing that theory today, were you?
Objection.
I'm going to allow that.
I don't know if I agree with that.
In this case, you provided reports recently.
Yes.
When did you provide your report? Was it April 6th
April 6th?
or was it May 6th?
I think it's May 7th,
May
if I'm
7th.
not mistaken.
So you provided a report May 7th, yes?
Correct.
And do you know when this trial started?
Early April?
You provided your PowerPoint. When did you provide your PowerPoint?
I think it would have been Thursday of this week.
Well, it wasn't last week.
Sorry, maybe Wednesday. Wednesday or Thursday.
Wednesday.
All right, so Allie says the trial has been long and drawn out. Yeah, we're all exhausted at this point. We want this thing to come to an end so we can move on to cash out.
Is that fair?
Yes.
In looking at pedestrian accidents, it's important.
I uploaded a shorts today. I'm supposed to. I just don't have time to edit. Hopefully, I'll have another one up tomorrow. Is tomorrow? What day is it tomorrow? No, tomorrow's Tuesday. That would not work. I'm trying to have shorts up on Mondays, Wednesdays, and Fridays. We'll see if I can actually keep up with that or not.
To try, if you can, understand the exact positioning of the body, isn't it?
If a collision occurred, yes.
And if a collision occurred, you can't always identify the exact position of the body, can you?
No, oftentimes it can be very difficult, yes.
You would want to know if it is a collision between a car and a pedestrian, whether the person was fully impacted or it was a clipping type incident. Wouldn't you want to know that if you could?
That would certainly affect the trajectory, yes.
And you would want to know, if you could, the body posture, whether the person was standing up straight or crouching.
If a collision occurred, yes.
Whether they were turning or standing straight or they had their arm out. That's helpful information, isn't it?
It can be, but when we're talking about how quickly this impact duration is, right? If you recall back to the PowerPoint, right, we're talking about a 10 millisecond window. So however the body is positioned at contact, that's how it's positioned. It's not going to be able to have any significant movement or change in orientation in that 10 millisecond window.
The position of the body can change the trajectory of the person who's hit, can it?
Sorry, can you repeat the question?
Positioning of the body, the way they're positioned, that can change the trajectory if they're hit after they hit. Can it?
It can, yes.
Whether they're moving towards the vehicle or away from it could affect.
Nellie says that we are doing cash out big like 50 big. Since Love and Funny are bringing the Rico. Honestly, I think, you know what? In all honesty, I think tomorrow, let's just move on to cash out. I don't know that there's any more point in following the Karen Reed trial until there's a verdict, because now we're going to have to play catch up with, is it Cash Out? I think that's his name. Yeah, so now I'm going to have to be playing cash out. I'm not playing catch up, playing catch up. So, yeah, I don't know that I'm doing Karen Reed tomorrow.
If
they have some relative velocity, yeah.
Trying to determine the point of impact when you're looking at a scene, it's important when you do trajectory studies to know where the point of impact is.
If you're going to utilize studies that look at projection of pedestrians when you're contacted at the center of gravity and you get projected some distance, you can rely on those studies, but you have to have an understanding of where the point of impact is and where the point of rest is.
If you don't have the point of impact, if you don't know the point of impact, you don't know the exact body position, that creates variables in your studies, doesn't it?
Well, again, talking about those studies, they're not applicable when you are contacting, for instance, just a limb or you don't have a center of gravity hit. Those when you're talking about how far will a pedestrian get projected, if it's like a forward projection or what's known as like a wrap projection where the pedestrian wraps onto the hood and then becomes decoupled, those studies are applicable there, but when you're talking about where there's minimal overlap between the body and the center of gravity, then you can't utilize those studies.
So you would not want to know where the point of impact is?
In this particular case, no, I don't think it would be helpful.
You would not want to know the body position?
I don't think that it would be helpful in determining, because again, we have to start with, is it consistent with a collision?
So you would not want to know the body position. That's what you're telling us. You don't want to know that.
Well, if the evidence indicates that the contact is inconsistent, then that's kind of where the reconstruction stops. You can't go to a point of impact and a point of rest if there was no contact.
So you don't want to know the body position.
Hold on. Can you answer that?
I don't understand this question, Your Honor.
You want
When
it?
you're doing studies, you don't want to know.
I think that's a pretty basic question. It's straightforward. Let me go see if I can find some, unless they're going to get into something here. Let me find some timestamps. What is this? 541. Let me find some timestamps.
The body position?
Not about to wrestle with Brennan and Wolfe all night.
Can you answer that, Dr. Wolfe?
Again, it depends on the type of impact. For the alleged contact in this case, you can't rely on those studies about impact location and point of rest. They're not applicable to
I was
this.
talking about studies as far as data, information. You, as the person doing tests, would you want to know the body positioning?
Objection. This is 5 times.
And this time we'll get an answer and that'll be it.
We got an answer every single time.
Can you answer that, Dr. Wolfe?
I feel like I've answered it the best I can, Your Honor.
Okay, next question.
You don't like that question?
Objection.
Sustained. Strike. Jurors disregard.
What was
Okay. When you were doing,
Your Honor.
Okay, next question.
you don't like that question?
Objection.
Sustained. Strike. Jurors disregard.
Okay. When you were doing these video demonstrations, was it important to be as accurate as possible?
Yes.
Data changes if information changes, right?
I'm not sure I understand your
That's a
question.
tough question. You want to be precise as you can in ultimately having a conclusion regarding data, don't you?
Yes.
Could I have PowerPoint page 12, please? Now look at force on the bottom. The first letter F signifies force, correct?
Correct.
And the last two letters, MA, signifies mass, yes?
Correct.
That's a very important part of that equation, isn't it?
Yes.
If you change the mass, it can change the whole analysis, can it?
I'm not sure I understand your question.
Let me make it more simple.
I
When you did
mean,
these tests,
sir, when you were
chose.
hold on, how is that question not straightforward? When Wolfe was asked about some practical exam that he failed or that he had to retake, he pretty much said that something along the lines of, if the math does not add up or if one thing is off, then the whole thing kind of dissipates. So why is that a difficult question to understand?
A arm from a hybrid 3 crash dummy, didn't you?
Yes.
You can take that down, Ms. Gilman. Now, when you made that choice, you knew that John O'Keefe's arm, based on the statistics and his weight of being 216 pounds, you knew that his arm weight would be 11.8 pounds, didn't you?
Yes.
And you knew that he was 6'1" tall.
Yes.
When you decided to choose an arm in this case, you didn't choose the arm closest to his weight, did you?
It was representative enough. Yes.
It was representative enough.
It was close enough. Yes, sir.
Close enough. Wouldn't you want to get an arm most closely related to his actual weight?
I don't know that you can have custom-made ATDs.
You probably can't custom make them.
Oh, I don't know. You guys went as far as smashing vehicles and doing all types of things. I'm pretty sure you can get whatever it is you want to get.
They have one that's 12 pounds. You know that, don't you?
Are you referring to the 95th percentile?
Yes, I am.
Yes.
So there's a 12-pound arm. Mr. O'Keefe's is 11.86 according to the statistics. You know that, right?
Yes.
You looked it up.
Yes.
You didn't tell us that on direct, though, did you?
I don't believe I was asked that.
No. Instead of choosing the 12-pound arm, which is 0.12 difference, you chose a much lesser weight, didn't you?
It was about 10 pounds. Yes.
No, it wasn't about 10 pounds. It was less than 10 pounds. Let's be exact. You're a scientist.
Uh-oh.
Let's be as precise as possible when we're talking about data. It was less than 10 pounds, wasn't it?
I think according to the spec sheet, I think it's 9.4 pounds total.
How about 9.38? You keep coming up a little bit. 9.38 pounds.
Sustained in that form.
May I approach?
Yes.
Showing you a photograph. Is that a photograph of your materials in this case?
Yes.
And in that photograph, it shows the arm that you used in your studies, doesn't it?
Correct.
And it shows that that arm weighs 9.38 pounds, doesn't it?
Yes.
And that is less than the 11.86 pounds of Mr. O'Keefe's arm, yes?
Correct. Yes.
You didn't put that photograph in your PowerPoint to make it clear to everybody you were using an arm that was a much lesser weight, were you?
No, I didn't put that photograph.
I'd like to move this into evidence, please.
Any objections, Mr. Jackson?
No, you are.
Of course, Commissioner, I'd like to show this to the jury.
Give him some minute, let Madam Court Reporter mark it.
217.
Yes, now you can play it.
Is it a video?
This is the arm that you used in all of your videos, right?
Correct. Yes.
And you can see, could you zoom in, Ms. Gilman, on the weight?
Hold on.
9.38 pounds.
Yes.
There's a bigger difference between 9.38 and 11.86 than there is 12 and 11.86, isn't there?
Correct. Yes.
So when you do the math, and have you done the math before on this? When you do the math, it's 26% difference, isn't it?
In terms of more force.
No, of mass, weight, 26% difference,
Okay.
right?
I'm going to trust you. Yeah.
Well, do you have a calculator?
I do.
Can you do it?
Sure.
Okay. And before you do that, you took this from Mr. O'Keefe's 6'1". You used a crash test dummy that, what is the height on it?
Well, the ATD, I believe, is 5'7". The Rescue Randy, I think, is 6 feet tall.
We'll talk about the Rescue Randy later. We have questions about Randy. But let's talk about this. 5'9". You said 5'7". It's actually 5'9".
Sorry, 5'9". Yes.
5'9". And it's 170 pounds?
171, I believe.
Mr. O'Keefe's not 170 pounds.
No, not his whole
He
body.
wasn't 5'9".
Correct.
Okay. So when you do the math and you take the 9.38 pounds based on the 171 pound doll, and you look at the percentage, doesn't it come out to 5.48% total body weight?
Yes.
And so the difference, when you look at it, it's a 26.3% difference from his actual weight, isn't it?
Correct. Yes.
And so I'm probably at the 6th grade level on this, but isn't it very basic that the more something weighs, the slower something has to go to have damage? And if something weighs less, other
Alex said, Brandon.
the force has to go faster.
Ellie said Brendan is getting all sassy. He is definitely, I don't know, they're beef.
The force is going to be greater if the mass is greater.
So if you throw a 5-pound rock into a window, you can throw it slower to cause the same damage if you have a 2-pound rock.
I don't know if I agree with that analogy.
So you agree that based on the 26% difference, in order to actually be accurate, to be specific, to be scientific, you then have to adjust the speeds that you presented on the demonstrations, and you have to reduce the speed by 26%.
I don't agree with that.
You don't agree with that. You think that having a lighter arm, so what you're telling us is having a lighter arm would cause the exact same amount of damage to the taillight studies as a heavier arm. Is that what you're telling us?
Well, if you look at, for instance, the 29 mile an hour impact test, that's significantly more kinetic energy. So the momentum of a 6,000 pound vehicle moving at 24 miles an hour, 29 miles an hour, that's going to overcome whatever the mass is that it's hitting at that point.
You're sidestepping my question.
Sustained. Ask a question, Mr. Glennon. Just ask a question, no more.
My question is, are you telling us that having a lighter arm does not impact the damage in these tests as opposed to using the heavier arm?
Certainly not in the field test, no.
And so you disagree that when you look at the weights of those arms, do you disagree there's a 26.3% difference?
Yes.
You disagree?
No, I'm sorry, what was your question?
Do you agree there was a 26.3% difference in the arm weight that you used opposed to John O'Keefe?
Yes, the hybrid arm compared to Mr. O'Keefe's arm, yes.
And you are denying that there needs to be an adjustment to your calculation because the mass MA is different. You're denying that.
I think, again, if you're, and this is something Dr. Rentschler, I believe, will
No, I want
touch
to talk
on.
to you. I don't want to talk to Dr. Rentschler.
Well, because when you're addressing the forces for injury and the mechanisms for injury, right, you would account for the difference in the weight.
So you're saying that it makes no difference that you use an arm that is 26% lighter. Is that what you're saying to us?
No, I don't think it would have made a significant difference, especially if you look at, for instance, if you're looking at the 95th percentile hand and the 50th percentile hand, they both weigh 1.25 pounds. They're the exact same weight. There's about a pound more roughly in the forearm and a pound more distributed in the upper arm.
That's not my question. It's not whether it's significant or not. I'm asking you, are you saying under oath right now that a 26.3% difference had no impact on the calculations in that study? It would have no impact at all.
The calculations, yes, but in terms of the damage, no, I don't think that 1 pound difference, when we're talking about something that's 6,000 pounds, striking something that's, quite frankly, whether it's 9.4 or it's 11 something, it's not, you're not going to get a difference in the damage.
Why not just have a 3 pound arm up there?
Well, I think that's unreasonable, sir.
What's that?
I think that's unreasonable.
What's the difference? It's a 6,000 pound car, according to you. What's the difference between 26% and 40%?
Well, I don't even know that I agree with your percentage because, again, you're accounting for the whole part of the arm that goes up to here, which we did not strike that part.
It's, how much lighter? 2 pounds and what? How many ounces?
Sorry, what was your
How
question?
much lighter is it? The arm that you used?
In terms of a percentage?
No, in terms of weight. The weight. 9.38.
Right.
Mr. O'Keefe, 11.86, right?
About 2.48.
And you're saying that makes no difference? None.
Not in the observed damage at those speeds, no.
Why didn't you use a 5 pound arm, sir?
I'm sorry, what was your question?
Why didn't you use a 5 pound arm?
Again, I don't know that they make a 5 pound ATD arm.
You didn't tell us when you did these studies, you didn't disclose in your PowerPoint that you used an arm that was much lighter than Mr. O'Keefe's arm, did you?
Where do you ask that question?
I don't know that it was, I didn't give the weight in the presentation, no.
Let's take a look at some of your testing. The first one was at 10 miles per hour, test A. You remember that test, right?
Yes.
Now, 10 miles per hour, if you had taken 26% off, would you agree it would change the actual speed from 10 miles per hour to 7.67 miles per hour? If you did out the math, if you did it specifically, accurately, precisely, would you agree, using the wrong arm, you make the deductions in the calculations, that 10 mile per hour test would actually be 7.67 miles per hour? Would you agree with that?
I would allow that.
No, because again, the arm is going to get accelerated up to that speed. So that the speed would still, that mass would still be accelerated up to 10 miles per hour. Same thing in the vehicle testing. It's going to be, given that weight difference, it's going to be accelerated up to that speed.
Now, can we see the video of test A, please? Now, this is your study, 10 miles per hour, you claim, with a arm that is 9.38 pounds, correct?
Correct.
Mr. O'Keefe, 11.86 pounds, yes?
Yes.
Yes. Okay. Now, this light on the end of this, you're trying to replicate the light on the back of a Lexus?
Correct.
If a Lexus at 6,000 pounds hits a person, the Lexus isn't stopping automatically, is it?
No, it would move at a common velocity with the arm.
It would continue to push forward through the arm, yes?
It may, yes.
And the arm can push into the light before the body turns, yes?
I don't know that I agree with that, no.
If the light on the Lexus, not at this speed, but if the light on a Lexus was broken or breaks and it hits the arm, it's not going to bounce off the arm, it's going to push through, isn't it?
It's going to move at a common velocity with the arm.
And that will move not only the arm, it will move the person's body, won't it?
It may, yes.
It may push the body, it may throw the body.
I don't know about throw.
And the light, if broken, will continue to press against the arm until there's separation. Isn't that fair to say?
It could, in some instances, again, it could bounce.
It could, because it's not always the same. It's a dynamic process, isn't it?
Sound.
It is dynamic, yes.
You could do the test many times and get very different results, couldn't you?
I don't know that I agree with that.
Would you get the same result every time?
I think you would certainly get similar results.
Every time.
If you had the exact same impact location and speeds, yes.
Well, that's my point. What if the impact location moved a little bit? Could it change?
Well, is Dr. Welcher changing? I don't know if, I was relying on what he provided
This
in
isn't
his
on
report.
Dr. Welcher. I'm asking you.
Objection. It is on Dr.
No, it's not.
Okay, so jurors disregard that exchange between counsel. Next question.
If the body position change, you may get a different result. Isn't that
Wait, let's go back.
Okay,
What did
This
defense?
isn't on Dr. Welcher. I'm asking you.
Objection. It is on Dr.
No, it's not.
Okay.
What did defense say? Let's put caption on.
He provided
This
in
isn't
his
on
report.
Dr. Welcher. I'm asking you.
Objection. It is on Dr.
No, it's not.
Okay,
Okay, I still did not hear what defense said.
so jurors disregard that exchange between counsel. Next question.
If the body position change, you may get a different result. Isn't that fair to say?
I was going after what Dr. Welcher had represented in his report analysis. So we did testing to analyze his orientation that he had demonstrated in his report.
You don't like that question either?
Objection.
Sustained.
If the body position changed, it could change the result. True?
I don't know what you mean by body position. Do you mean the whole body, the arm? What part of the body?
Okay, let's start with the arm. If the arm position changes, it could change the result, couldn't it?
Well, I'm not aware of any other orientation that Dr. Welcher provided in his analysis report as to alternative orientations.
If the arm position changed, could it change the result?
Yes, I mean, I presume if you don't have your arm on the taillight, then yes, you'll probably get a different result.
What if it's bent in a different way? Could that change the result?
Again, I haven't reviewed anything that indicates that there was a different orientation that Dr. Welcher suggested.
You're a scientist, right? You can think. I'm asking
Whoa.
you.
Oh my goodness.
Just a
Hold
general-
on. Brennan said this man should use his brain.
A question over here. If you bend the arm, could it change the result?
It could.
Why is that difficult to answer?
Okay. When a pedestrian is struck, they are not held stationary on a harness, are they?
No.
In this case, the crash test dummy is on a harness,
Yes, he's supported.
strapped
Yes.
by its hips or pelvis.
Yes.
That's not real life. That's not how a pedestrian is usually when they're hit, right? They're not strapped to a harness, are they?
No, and again, the purpose of this test was to evaluate the arm. We're not looking at the whole body here with this test.
And when we talk about injuries, part of injuries is not just the impact, it's the drag, in this case, from the car, isn't it?
It could be, yes.
But when you put the dummy on a harness, restricting or restraining its movement, it is not going to replicate hitting somebody and their movement, including the drag, is it?
I don't know that I agree with that, because it will replicate, again, when we're talking about that impact pulse of 10 milliseconds, it will replicate that. And that's ultimately what we're after, is what's happening in that 10 millisecond window in terms of the contact and the damage and the acceleration.
I know that's what you're after. What I'm asking you is when you end it, when the light stops, unlike a Lexus, and the dummy is stationary, unlike a person, it affects the aftermath, the drag and the push after, doesn't it?
Yes, the kinematics would be different, likely, if it's not restrained like that.
In real life, pedestrian usually is not restrained, are they?
Correct.
In real life, a 6,000-pound Lexus, upon contact with an arm, doesn't usually stop on a dime, does it?
No.
Could I have the photo from test A, please? And so there is no break, but there is a crack in this light that was a result of this experiment where this light hits that restrained dummy, yes?
Yes.
And this is at 10 miles per hour in your world and 7.67 if you take off the 26% weight.
Changes to that form.
We can move to test B, please. Now this test B, a similar test, it has the same limitations, doesn't it? This dummy is restrained at the pelvis.
Yes.
Could you show the video, please? There's two videos. We can see the first one.
Hold on, what?
We can see the first one. And was the dummy restrained by its head as well?
Yes.
Was its arm restrained in any way?
It was tethered, but it was free to move.
This test you have is 17 miles per hour with the arm that's 9.38 pounds. Mr. O'Keefe, 11.86 pound arm. If you consider that 26% difference, wouldn't it be fair to say that this test, rather than replicate 17 miles per hour, would actually replicate 12.6 miles per hour?
No, can you answer that?
Not the way it's phrased, no.
And so looking at this test, test B, which you say is 17 miles per hour, can you do a calculation for the 26% difference, or is that something that you don't think is fair?
I don't think that'd be a fair way to characterize it. Again, if no matter what the mass is there, if you're accelerating it, if you're impacting at 17, that arm is going to move at 17.
Well, not just the movement, the damage. If this arm was 5 pounds, do you think the test would have the same exact result?
If it's 5 pounds,
Yes,
probably would be less damage.
it would be less damage. So to get this amount of damage, you would have to increase the weight, right?
I see.
Sorry, what was your question?
To get this amount of damage,
You heard that.
you couldn't use a 5-pound arm. There'd be less damage with a 5-pound arm.
Correct.
Right, because the less weight you use, the less damage at that speed. That's
Correct.
basically how it works.
Correct.
Okay.
Okay. So in this test, if we could run that back again, you have a restrained dummy at the hips and the head. There's no follow through of the light or the body that's attached to that arm, correct? And at this speed, you can see the shards of taillight. You can see them move, can't you?
When you
See
say
what
move, you mean just. When you say move, you mean.
The shards of taillight. You can see them move, can't you?
When you say move, you mean just.
Not stationary.
Yeah, I mean they're moving from the taillight as they break.
Detached from the taillight.
Correct, they're
And
broken.
that could create a debris field, yes?
I see.
Yes.
I see where
You can see them floating in the air, some of them actually floating and then touching the sweater. Do you see that?
Possibly some of it might be, again, some of that.
Basically is relating this to John O'Keefe. Part of that taillight debris found in his clothing and the scattered taillights, in the vicinity where he was found.
Polyurethane foam.
Yeah, some might be. And why don't we play it again so we can see clearly? Some might be taillight shards too, right? That black object spinning, that's not poly foam, is it?
No, it would not be.
That'd be taillight shard, right?
Correct.
And so even at this speed, you can see in this type of collision, there is significant amount of taillight shards that are broken from the taillight and spewing into the air. Yes?
Well, I think on the one of the slides I had, I think I showed the fragments that were left. And from what I recall, I think there was 4 pieces from the taillight, from the lens.
If you could put that back a little so Dr. Wolfe can see it again to the point of the collision. Even at this speed, go ahead.
Oh, I got a TikTok, by the way. I completely forgot about it. It's I Want a Real Lawyer. I've not gone back up there to see what it's doing, but I do have a TikTok. I don't know what else I'm supposed to do with it, but I do have a TikTok. I also cannot guarantee that I can keep up with it or that I won't delete it, but today I created a TikTok.
Stop. You can see pieces, large, small, medium, maybe even microscopic, are now breaking off from that taillight and being littered into the air, aren't they?
Yes, there are pieces coming off.
If we can go to test C, please. Now, in test C, you actually use only an arm. Isn't that fair to say?
Correct.
You don't use a body or a crash test dummy.
No.
You don't, in fact, this is not the 12-pound arm either. This is the 9.38-pound arm.
Correct.
And when you do this test, you have the arm. It's basically just an object suspended in the air, isn't it?
Yes.
And you said, I think on direct examination, I think you said that this is the same as if it was on the dummy. Is that your testimony?
Well, in terms of, again, the amount of weight that would be interacting with the taillight, whether it's attached to the dummy or not, what's in direct contact is going to be the same.
Well, the fact that it's just floating up in the sky like that, it's very different than if it was attached to a person or a dummy, isn't it?
In terms of how it moves immediately after the impact, yes.
Not just how it moves, as far as the impact. Isn't it different?
I don't know that I agree with that.
Okay. Well,
That's what I think.
wouldn't you say that in addition to the arm, if you had another 200 plus pounds being held down by gravity, that would affect the force that's acting on the arm?
Allie's following me.
Well, the arm again is going to be accelerated, but the center of mass of the body's not going to see that acceleration.
Have you testified before in this case about the importance of the full body and gravity?
I'm sorry, what was your question?
Have you testified before in this case about the effect of gravity and the full force of a body as opposed to just an arm?
Yes.
Okay. And do you remember whether you thought it important on a previous time you testified that there is significance to the arm would be attached to a 200+ pound body and there was the issue of gravity that would affect force?
From what I recall, I think that had to deal with whether or not the pedestrian would be projected based upon an interaction with the arm or a full-on center of gravity hit, right? When we're only hitting the arm, we're not hitting the CG of the body.
You did test B, and you claim it was at 17 miles per hour, test B.
Correct.
And we saw the damage. This is at 15 miles per hour, test C. Could you play this, please?
Let's see.
It might be a delay, so you could fast forward a little bit, please. How many times do you think that arm spun around?
I don't know.
That's not what would happen to a person who got hit. Their arm wouldn't spin through their body like that, would it?
Correct. It
Their
would
arm
not.
wouldn't spin that many times.
No.
There'd be the pull of their body weight. Yes.
I'm sorry, what was your
There'd be
question?
the pull of their body weight,
The body weight, yeah, would affect the movement afterwards, yes.
gravity. Yes.
Yes.
Yeah.
How much more do
And
we
so
have?
there's a reason why you do this test at 15 miles per hour. Is there a photo related to this, to the damage to the taillight? There is a
Is that-
reason why at 15 miles per hour, the damage is much different than the other test at 17 miles per hour, isn't there?
Correct.
Right, because at 17 miles per hour, you have a dummy that is strapped by a harness in its pelvis. When it's hitting the arm, it's affecting it much differently than just a arm floating in air. Yes?
No, I don't agree with that. The primary reason there's a difference in the damage is because of the amount of the arm that's outstretched and interacting with the taillights. There's a difference in those two tests.
Mm-hmm. And so the body and the weight of the body, you're saying, has nothing to do with the amount of damage.
Not in these tests, no.
So when somebody gets hit, does the body weight have anything to do with the damage? Not just the area that gets hit. Does the body weight affect it at all?
Not in terms of the impact, like the rest of the body, it's not going to matter if, for instance, only my hand, like in that last test we just saw, it was the hand and the wrist. How much my stomach weighs, my head weighs, is not going to affect the damage to that taillight in that interaction.
And by the way, this test, you said 15 miles per hour. If you consider the 26%, you're only at 11.1 miles per hour. Is that the right math?
Again, I don't agree with that because if you look at the data and you integrate the acceleration data to get the speed, right, that we saw in those plots, the hand basically gets up to, I think it was 14 or 15 miles an hour. It reaches that common velocity of the vehicle.
Stop.
Let's go to test F.
I want
On
to
test F,
forward.
you placed the dummy more behind the vehicle, didn't you?
Correct.
Fine.
And when you tested, you put it more behind the vehicle. This is more of a full impact than it is a clipping, isn't it?
Certainly, yes.
And when you put this dummy behind the car, this was not a legitimate crash test dummy. It was a different type of dummy, wasn't it?
Yes, it's called a Rescue Randy.
A Rescue Randy. And that is not typically the type of dummy that you're going to use for crash tests, is it?
I wouldn't agree with that.
When you did the Rescue Randy and crash test F, did you use the 12-pound arm or did you stick with the 9.38?
The hybrid arm wasn't attached to the Rescue Randy. And
The hybrid arm was not. Is that what you said, or it was?
it was not. No, not in the full impact test.
Okay, so what was the weight of the arm on the Rescue Randy?
I don't know specifically the weight of the arm. I know that the total mass of the Rescue Randy was 200 pounds.
Isn't the weight of the arm important when you're talking about impact with the arm?
I don't think relative to the rest of the mass of the body.
So now the mass of the body counts, but before it didn't.
Objection.
Sustained enough.
Okay. If we can see in test F, we have some photographs. Start with the first one, if you could widen that, please. Now, this is a direct hit.
Correct.
Is this simply a photo or a video? Could we go to the next one, please? So the rescue Randy's placed much further in the car than the other type of test that would be more similar to a clip, yes?
Correct.
Next photo, please. And that is the result of the impact.
Correct.
Do you see the debris field?
Yes.
Is it near rescue Randy?
Some of it is, yes.
Yeah, it's spread out a little bit, yes?
That's fair, yes.
But it's not right on his body. It's a distance from his body, yes?
There may be some, I can't tell from this photo, there may be some around his body, but yes, there's also debris close to the Lexus as well.
And could we, and this is the demonstration where you didn't turn on the videotape, so we don't have a videotape?
Correct, we had the false start, yep.
What's that?
We had the false start.
False start. Is there another picture after this? Those clothes. Are there holes or tears in the clothes?
Yes, there's damage that's consistent with road rash when clothing or a body makes contact.
I think I'm gonna fast forward here because I want to get into cash out. Let's just get into cash out quickly. Let's watch a bit of the trial. Why is that not popping up? Is it on Law and Crime or no? Okay, 11 live. Let's see. Let us
11 Alive Plus.
Let's actually go to the live stream. Let's see if we get what we need here. I don't know. They have the weather and everything. Cash out trial. 11 Alive. Okay, dang, 2 weeks ago? 2 weeks ago. Why? I wonder if they tagged his videos with Young Thug, because why is he popping up? Let me see.
Court continues today in the trial of...
Dang, she's stunning. That's not what I'm looking for, though. Okay, so apparently he hired the attorneys with a wonderful beard.
Atlanta rapper Cash Out, the rapper whose real name is John.
Ali, where can we watch this? Brooklyn says, did everyone fall asleep here? I'm tired. I'm ready to move on to cash.
Michael Hakeem Gibson faces a number of... Prosecutors say Gibson did not act alone.
I'm tired of the Karen Reed trial. I'm just it's starting to feel like the YSL trial because I got to a point where I actually got tired of the YSL trial.
They say 4 others helped him use their music label to recruit women. Prosecutors say the group promised money and status and then forced women into commercial sex.
All right, can we find the actual video?
11 Alive.
I don't know. Where do I find his trial? That is the real question here. Dang, do they cover? So I guess it is a new station. So I suppose it makes sense why they'll have all of this up here. What happened? 27-year-old. Let's see. Yeah, this is too much. They have a lot going on out there in Atlanta. Oh, I think I watched this. No. This is unrelated. Sometime today, I was recommended a video about a 6-year-old that was shot in Smyrna over the weekend out there in Georgia. I have too much going on. Too much going on. I cannot. Oh, this is still going on? Oh, no, I cannot find the video. Because I thought, unless, hold on, how about we do this? What if we change that? Will that work? Will that work? It's still not giving me what I need. Uh-oh, somebody's testifying against him. Where is it? I cannot find it. Let's see if Ali... Brooklyn says, no, there was court Friday. What do you mean by that? Okay. Let's try that. Let us try that. Still not giving me anything. It's not giving me an actual link. What's going on here? Oh, Nicholas Cruz. Let us see. I know that it was recommended to me randomly. No, it cannot be last week. Last week was too crazy. I think it was the week before. It was recommended to me, and I for sure thought they said that man's name was Crash Out, but apparently not. So I don't know. This is why. So that's not what I'm interested in. Well, I don't know what happened to him. Let's try again. Law and crime trials. Let's see if that's it. Let us see if that is it. I'm so tired of this Karen Reed trial. I watched a little bit of this trial. Let's see, latest. I guess it's not up there. You have Lori. You have Koberger. I think that's going to be the biggest case of the year. The Koberger trial. Well, it's not there. The other one is law and crime what? Law and crime something. Law and crime, their network. Live videos. Dang, is that the Punisher? The New York Punish. Sheesh. I don't even want to touch that stuff. I'll leave Diddy alone. I'm not touching any of that. Juror number 6 is kicked off. Maybe in the morning I can create a short. Otherwise, I'm going to move on to something else. Well, I don't see cash out. Well, it seems like we cannot actually cover cash out. Brooklyn says the Matthews father and son duo are good. There is the Megan Jackson going on, which is pretty good. I watched a little bit of that. I initially started watching when her daughter was testifying against her, and that was difficult, or at least it was difficult for her to testify against her own mother. Okay, so Allie will find it and send it to me. Okay, apparently the first link. Okay, so search Rico. All right, let's see. Cash out Rico. I think this is somebody else's channel. I suppose this is a video dedicated to the trial. No, that's not helping me. That is not helping me. Well, I don't know. I don't know if I'm censored. I don't know what's going on. Well, I wanted to see what this was. Outfit.
Karen, are you hoping the jury will reach a verdict?
Okay, so why doesn't Jackson want them out there screaming? Does he think the jurors are going to change their minds, or what's going on? I don't know why they continue to have Karen Reed in front of these cameras. Brooklyn said. Brooklyn has the sign up.
Okay, no comments right now, guys. And do me a favor. The cameras weigh a shit ton. Give me some room. She needs room. We need room. Okay, let us walk.
And we need
So why aren't they commenting this time
room
around?
on the sides as well.
Yep, just let us walk. You'll get all the pictures you need.
Take it in there, Karen.
Okay. Is that it?
Karen, do you have any comment you want to make, Stephen, today?
How you're feeling? Any message?
All right, can they clear the way?
A little faster, guys.
Don't trip.
That it? Is that all the mess? I don't have time for this. Wait, did they get back up there? Are they making another statement? What's going on? Is that just a repeat? Jackson said he's worried the jurors are gonna hear all that yelling and screaming and convict Karen Reed. Let's see. I know there's nothing to it. So why is this? Why is this? I don't know. Leave that alone. I'm supposed to be searching for cash out. So let's search for cash out. Let us search for cash out. Well, I don't know. That's all they have. So I don't know. Somebody else was up on this case, what, 3 years ago? I don't even know who Cash Out is. I'm not, I usually know who these people are, but Cash Out, I have no idea. Benji, no problem, no problem. Do your job, do your job, do your job. Okay, Brooklyn says they're still under gag order. I still don't know why. I don't know why they have Karen Reed talking to the media to begin with. I've never understood that. And nobody's going to help me understand that because I don't agree with that move. Well, Benji, we're trying to find our next case. I got tired of the cross-examination. I'm really, at this point, I'm over the Karen Reed trial. I watch this guy every once in a while. I don't know, I think he's entertaining, but I'll leave it at that. Let's see. I've watched this video sometime. Must have been around last year. Well, Cash Out, I don't know. Nothing's coming up on Cash Out, so I don't know what to do. I don't know what to do with that. I do not know what to do with that. But Allie said she's going to send me the video, though, so I'll wait for Allie to send me the video. And then I suppose I call it a night here. Yeah, I'm going to call it a night. I'm exhausted. We'll see what we come up with if Allie sends me a link, or if I'm able to find the link to Cash Out's trial, then we start with Cash Out. If not, I'll have to find another case. My real interest at the moment, again, the two cases I was looking forward to this year, definitely Karen Reed, even though I'm tired of her. Karen Reed and Kohlberger, the Brian Kohlberger case, because I remember exactly where I worked when I woke up and I found out that an individual has been charged with offing college students. I'm like, that sounds like a tough one right there. And the case has definitely proved challenging for the defense through and through. That's not going to be an easy case. It's going to be an easy case for the prosecution. The defense, on the other hand, I do not know what stops they're going to pull. It's just one of those cases. It's one of those cases. Yeah, but if you guys, I don't know, let me know what other case do you guys want to move on to? Because in this moment, I do not know that we get to the Cash Out trial. I don't know, when is YNW Melly going to trial? Let's take a look. Because that one I can definitely do because I watched the first trial. So I know what's going on. Hold on. When is the trial date? I cannot believe that trial was in 2023, though. It just seems... Dang, next year? AI is failing me. AI is failing me. They're not giving me what I'm looking for. They're just talking about a whole bunch of other things. I need them. Okay. No. No, this is outdated. This is an article from July 8, 24. That's not working for me. It's not working for me. Because I think it says September 10, 2025. That's still a long way. That's a long way. Up here, I see September 10, 25. This is an article from July 8th, though, so I don't know how accurate that is. Ali says his lawyers asked to delay the trial until next year. Was that motion granted? No. because I remember the last time we looked into this, which was sometime around January. I remember that because I got stuck on the highway. Okay, I did not have snow tires. I got stuck on the highway. A highway was not plowed, and I got stuck up there, and I had to be rescued. So I remember on that day, um, we watched a bit of the pretrial motions where the judge pretty much said this kid has been incarcerated for over 1,000 days, and he wants this case to go to trial without any adjournments. Ali says it's been delayed since then. His lawyers recently, what? It's been delayed since then. His lawyers recently, okay, I think this is asked, and I think it was granted. Okay, so we have, hold on. I won't be able to view this because I don't have Instagram. Oh, I did create a TikTok, you guys. Allie's my first follower. It's I want a real lawyer. Yeah, I want a real lawyer. Right, that's a name. That's a name on TikTok. I was getting confused. I was about to say at gmail.com, but I don't think that's how TikTok works. I'll be posting over there. That's a plan. I might end up deleting it because I don't know that I want these TikTok people to have my information. All right, so this is from an hour ago. It says the state just filed a motion to reconsider the trial date for YNW Melly. They're trying to challenge the judges. I don't think I can actually read the rest of this. I was worried I cannot read it because I don't have Instagram. Anyways, they're trying to challenge the judge's decision to move forward with a September 10, 2025 trial. A hearing is set for July 9th, the same date set for reconsideration of bond. Okay, so it sounds like, okay, this is confusing because the caption says the state just filed a motion. Let's just find the goddamn motion. That's what we're gonna do. I think this is Broward County. I think I might be wrong, but I think it's Broward County. Broward County, Florida. YNW. Melly. Today's what? June 16, I think. 20. Oh shoot, it's my little cousin's birthday. I forgot to send her a message. I forgot to. No, this AI stuff is out of control. They're not giving me what I need. Anyways, I don't have time to go through all of this. Ali says they're asking due to his mental health and some other things. I'll send you a link. All right, sounds good. So tomorrow, let me just figure out, because I'm definitely done with Karen Reed. I'm done with Karen Reed. From here on out, I think the only thing I need to address will be real things questions. I have to figure out how to address that. Do I just create shorts, or do we have an actual discussion? I have to figure out how to do that. Other than that, I am moving on from Karen Reed. I'm done with Karen Reed. I'm done with Karen Reed. Brooklyn. Sometimes I think Brooklyn is. I don't know. Brooklyn, are you the same person? Sometimes I have a hard time discerning if Brooklyn is always the same person or if, I don't know. This is going to sound weird, but I often feel like Brooklyn takes on a different personality on specific days. I know that Brooklyn watches, I think he shares an account with his wife. So I can never really discern between who's writing out the messages, or maybe Brooklyn is just wishy-washy. that could be another explanation, because now Brooklyn is saying hopefully a verdict tomorrow. I don't know that we get a verdict tomorrow. Tomorrow's what? Tuesday? That would be what? I think when we left off today, it was 9. They had deliberated for 9 hours. if I'm not mistaken. But I don't know, Brooklyn. I don't know. Maybe verdict. I'm just done with this case. But while we're here, though, let me see if I can find. That's something else. I don't want to share my screen anymore. I need to go. I need to go. What time is it? Dang, it's much later than I planned on being up here. All right, folks, I'm calling it a night. Regular time tomorrow, 8:30 p.m. Eastern time. And then I suppose during the day I'll figure out where we are moving to next. But I'm definitely done with Karen Reed. Okay, Brooklyn said, same. There's someone else, Brooklyn. And Brooklyn, I'm about to change and use my real name. All right, Brooklyn. Sure, I don't know if you want to use your real name up here, but you know, it's YouTube, and I suppose a lot of people do actually use their real names. So, all right, I'll talk to you guys tomorrow. Thanks so much for tuning in. And if you do have suggestions for a trial you want to move on to, let me know and we will take it from there. As for right now, I gotta go. I need to go. Benji, enjoy the rest of your shift. I'll talk to you guys tomorrow. Bye.